Hi, my name is Christopher Braddock, and I'm an attorney in Denver, Colorado. I graduated from the University of Denver Law School and passed the bar in 1993. For the last 24 years, I have been specializing in defending the criminally accused. One of the most frequent questions I get are questions regarding being accused of a sexual offense. Sexual offenses generally are unlawful contact crimes, such as sex assaults, child pornography, and internet sex crimes such as sexting or luring. If a sexual offense allegation has been reported to the police, there will be an investigation. One of the first things that the police will do is look for physical evidence. This could be, for instance, in a sex assault case, a DNA evidence, or other physical signs such as trauma. To preserve and collect this type of evidence, the police will request a nurse examiner to inspect the accuser, looking for any physical signs that will corroborate the accuser's allegation. The nurse will collect any DNA evidence as well as photograph any injuries. The police will also look for corroboration of the accusation, either from the witness or perhaps by showing that the accuser's description of the location was correct. One of the last investigative techniques that the police will do is to obtain a statement from the target. This statement might be a formal statement taken at the police department, or it might be a pretextual phone call. A pretextual phone call is where the police will ask the accuser to call the target to discuss the incident. This phone call will be scripted and it will be recorded for future use in the case. The most important piece of advice I can give anyone who is facing a sexual allegation is not to speak to the police or anyone besides their attorney regarding this incident. In Colorado, some of these crimes are punishable under the indeterminate sentencing scheme. That means that if you are found guilty, a court will sentence you to a range in prison that includes natural life. For example, a person convicted of sex assault could be sentenced to a minimum of 4 years to natural life in prison. There is no mandatory date when you have to be released from prison. As soon as someone hears that they are the target of an unlawful sexual offense investigation, they need to hire an experienced defense attorney as soon as possible. Another frequent question I receive concerns being removed from the sex offender registry. In Colorado, if you are convicted of an unlawful sexual offense, in this state or in any other state, the offender must register. To be removed from this obligation, the offender must petition the court. Thus, if you do not petition, you will not be removed. The length of time one must register before you can petition to be removed varies. For instance, for a deferred, the defender can petition to be removed as soon as his deferred has finished. For some misdemeanors, the length of registration is 5 years after completion of probation. For more serious misdemeanors and low-level felonies, the term is 10 years after the completion of probation. For serious felonies, the term is 20 years after the completion of probation. And for some very serious felonies, the offender must register for natural life. The decision to have this obligation removed is discretionary with the court. Normally, the court requests input from the district attorney, victim, probation, and treatment providers. To be eligible to petition to be removed, the offender must not violate the following criteria. First, you must be a resident of Colorado or have suffered your conviction here in Colorado. Next, you cannot be classified as a sexually violent predator or have been convicted as an adult of sexual assault on a child, sexual assault on a client by a psychotherapist, or incest. Finally, to be able to petition for removal, you may only have one conviction for an unlawful sexual behavior offense in Colorado or any other state. If you meet these criteria and the offender has a Colorado conviction or the offender is a resident of Colorado but has suffered a conviction in another state, you may petition the district court in the county that you reside in for removal from the registry. Normally, this process takes several months and may involve a lengthy court hearing. If you have any questions regarding sexual offenses, registration, or any other criminal matter, please call me at 303-675-0100.